Welcome back to our last panel of the day. I'm so pleased to be moderating it, and so I won't take much time here. What are we going to be talking about in this third panel is something close to my own heart. I know I teach constitutional law, as a lot of you know, and direct our Capital Center for Public Law and Policy. And so we're always thinking about levels of government. Okay, that is, it's not just a question of what needs to be done, but it's also always a question about who gets to decide what needs to be done and who gets to do the doing. And so as part of that, of course, we run into problems of conflicts when everybody wants to do it. But we also sometimes run into buck-passing problems, too, when nobody really does. And in either case, we want to figure out who it is, who gets to do it, and how the entities that can do this thing we need done can work together the best way that they can. And so certainly that's what our panel is going to be talking about and helping us with today. What we're going to do, I know with the first couple panels, we had the speaker speak, and then we had questions afterwards. It's seeming with this panel, we have three panelists, and then also what they're talking about really is rather closely related. So we're thinking maybe it makes more sense with this panel to have the speakers speak seriatim, and then we'll take questions, and the appropriate person can respond to them. So let me give a brief introduction. I'm going to give an introduction for each of the speakers, and then I won't have to interrupt them as they proceed. So our first speaker is Benjamin B. Wagner. He is our United States Attorney for the Eastern District of California. He was appointed by Barack Obama in 2009. And before that, let's see, he'd gone to Dartmouth, he went to NYU Law, he worked in New York at a big firm for a while, and then moved out here and was in the U.S. Attorney's Office for maybe about 17 years before being appointed to be the U.S. Attorney. He's lived in Indonesia, South Africa, Lebanon, and Turkey. And he spent a year in Indonesia being the resident legal advisor there, advising the Attorney General there and others about corruption issues and dealing with the embassy. In the U.S. Attorney's Office, he was chief of the Special Prosecutions Unit for 9 years, doing all sorts of different types of cases, including corruption cases and anti-terrorism cases. And hot off the presses is his editorial that appeared just a couple of days ago in the Sacramento, Modesto, and Fresno Bees, titled, I don't think it's your title, but I think they did it for you, but it summarizes the theme, Unify with Muslims, Don't Vilify, to Thwart Radical Sects, S-E-C-T-S. All right. Then our next panelist is our own Gerald Caplan, who was dean here at Pacific McGeorge for a number of years and is now a professor here at McGeorge. He was in D.C. before coming here, doing a number of things related to government as well. He was an assistant United States attorney, general counsel for the Metropolitan Police of the District of Columbia, director of the National Institute of Justice, U.S. Department of Justice, president of the Legal Services Corporation, and deputy director of the Federal Trade Commission's Consumer Protection Bureau. He has written a lot about criminal law, and that's what other things he writes about too, but today he's going to be talking about criminal law as well. And then we're also welcoming Professor Sam Kamin, who is he's the director of the Constitutional Rights and Remedies Program, and he's also a professor of law at the University of Denver Sturm College of Law. He went to Amherst and Bolt, and then also got a PhD at Berkeley. And he's active in the Law and Society Association, doing law and social science work. And I also see here, the contributor to the Money Law blog. He's written a number of articles, some of them on the three strikes, and has co-authored several books on that as well. So we will look forward to hearing from all of our panelists, but we'll let the U.S. Attorney speak first.
Thank you, Leslie, and thank you for inviting me here today. Thank you, Professor. As you probably saw from the brochure, my outline was the shortest because my message is the shortest, which is it's illegal under federal law. So, so it's pretty simple. But since this is a forum and I was invited here, I can elaborate a little bit on that statement. I'm going to start with the Controlled Substances Act, which is the statute that I'm talking about. Under the Controlled Substances Act, which has been around since 1970, marijuana is a Schedule I controlled substance. The Controlled Substances Act divides various narcotics and controlled substances into 5 different schedules and ranks them according to different criteria. Marijuana is placed in Schedule I, which means that Congress has found that it is a drug that has, number one, a high potential for abuse, that it has no currently accepted medical use in treatment in the U.S., and that there is a lack of accepted safety for use of the drug under medical supervision. And those standards are found in Title 21, Section 812B1. So growing, distributing, possessing marijuana in any capacity other than as part of a federally authorized research program is a violation of the Controlled Substances Act. And there's no medical necessity defense to a violation of Title 21. As far back as 2001, the Supreme Court in the Oakland Cannabis Buyers Cooperative case ruled that there was no medical necessity exception to this to federal law. There is medical research that does go on under the Controlled Substances Act. I don't know a lot about it, but there are apparently 100 DEA-registered researchers eligible to study marijuana, and there are at least 18 of them who have requested and received permission to conduct research on human subjects. So there is federally authorized research that is going on marijuana, but the Controlled Substances Act envisions a closed system in which everything that is not within that research program is essentially illegal under the Controlled Substances Act. Given that that's the state of the law, under the Supremacy Clause, there's really no, there's a lot of discussion in the media about the interplay between state and federal law, but really from a criminal prosecution standpoint, which is, as a prosecutor, that's kind of my orientation. From a criminal standpoint, in terms of prosecution, there isn't much interplay. There's the Supremacy Clause, we win. So it's basically illegal under federal law. In Gonzalez versus Raich, a more recent Supreme Court case from 2005, the Controlled Substances Act was ruled to be not unconstitutional under the Commerce Clause. It also talked about the Supremacy Clause. So there have been a number of efforts over the last few years to challenge various federal laws under the Commerce Clause, the effect of the Supremacy Clause, what kind of interplay it has under state law, whether there's a medical necessity defense, and all of those have been shut down. So what most advocates of marijuana at the state level have turned to, I think, recognizing that the sort of the invincibility, essentially, of the Controlled Substances Act, absent an amendment from Congress or a rescheduling of the drug from Schedule I to one of the other schedules, is they've turned to prosecutorial discretion. Okay, it's illegal as a matter of federal criminal law, but what are you prosecutors really going to do about it? So there has been a lot of discussion about something that we call in the trade the Ogden Memo, which is a memo issued in October 2009 by the Deputy Attorney General, David Ogden, which talked about the prosecutorial discretion and marijuana and state laws involving marijuana. In our criminal system, unlike, say, the one in Indonesia or a lot of other countries, we have this concept of prosecutorial discretion, which is very important to what we do as prosecutors, and it informs a lot of our decisions every day. And under the doctrine of prosecutorial discretion, prosecutors do have discretion to decide in particular cases what kinds of cases to bring, how to charge a case, how to settle a case, and so forth. We are not duty-bound to prosecute every possible violation of every possible crime that we are aware of. But that being said, there are important limits to prosecutorial discretion. We are not free to ignore the law. We enforce the law. We don't make the law. We cannot carve out loopholes in the law. We cannot decide, well, we like this law, we don't like that law. there are limits to prosecutorial discretion and to our duties as prosecutors to enforce the law. So turning to the Ogden Memo, the Ogden Memo was a memo which basically said, and I think it's been broadly misinterpreted, possibly intentionally so by some people. It's been misinterpreted to be sort of a signal. A lot of people have interpreted it as a signal that, well, the federal government is not going to prosecute marijuana cases, and that's not what the memorandum said at all. And it's a short memo, and it's on the internet, and people can go look it up, so I don't need to get into the verbiage of it. But the gist of it was that it is not a good use of federal prosecutorial resources to be prosecuting people like cancer patients who are possessing and using small amounts, personal amounts of marijuana as part of a medical regime in connection with their illness. But there are substantial federal interests at play when it comes to marijuana cultivation, marijuana cultivation and distribution, and that we will pursue those cases regardless of state law. And there was a nice, for the breadth of it for prosecutors, a catch-all at the end, in which it noted that the memo is not a defense. This is an issue for prosecutors and their use of their resources, and that prosecutors can pursue cases even if there's unambiguous compliance with state law, if that's an appropriate thing to do under the Controlled Substances Act, and there are otherwise federal interests at stake. So if we're talking about federal jurisdiction, there's no question that we can prosecute any of these cases. But reality is that we cannot prosecute every single case in the state of possession of marijuana. We're not going to replace every district attorney in the state. We're not going to prosecute every possession of marijuana. So like any area, whether it's other types of narcotics, whether it's violent crime, public corruption, there is a process of determining what are the most vital issues, what do we have to focus on with our limited resources. And so we look at what the federal interests are. One of those interests is the national market in narcotics. One of the important parts of the Controlled Substances Act, which is in Section 801 of Title 21, were findings by Congress that indicated that in a drug market you cannot differentiate between an intrastate and an interstate market in narcotics. And for that reason, the Controlled Substances Act explicitly contemplates not just the regulation, the prosecution of, say, the interstate movement in drugs, but the prosecution of purely intrastate activity because it is part of an undifferentiated market with narcotics across the country. So one of the things that we are interested in is prosecutions that impact a national drug market. And when it comes to marijuana that's grown under Proposition 215 here in California, that is a real concern. We have we're prosecuting a case in our Fresno office in which a number of individuals are alleged to have grown marijuana in Fresno County under Proposition 215. They had doctors' recommendations staked out around the marijuana. But we arrested some of them in Boston because they took the marijuana, shipped it across the country, and were selling it to Jamaican organized crime figures in Boston. So that is not something that California law authorizes. Clearly, it was grown intrastate under the auspices of 215, but clearly was being used as part of the national market. We have a case that we just superseded this week, similarly, in which individuals were shipping marijuana to Texas. And I'm aware of cases that are being prosecuted by a district attorney in this district involving people from Texas who came to California to set up marijuana grows here in California because they thought it was a more favorable regulatory environment in order to harvest it and then ship it back to Texas. So those kind of prosecutions, clearly federal interest. It doesn't matter what 215 says, what state law is, we're going to prosecute those cases. A second thing that we're concerned about is the intersection between marijuana cultivation and organized crime and crimes of violence. Marijuana is highly, highly profitable. It's like money. And there are a lot of well-meaning people who are harvesting and cultivating marijuana, and a lot of not so well-meaning people, because it has been a lucrative source of income for drug trafficking organizations of many sorts. So we're very interested in that. One of the things that we have been prosecuting here in my office are indoor marijuana grows that are associated with Asian organized crime groups. And that, again, is going to be something that we're going to continue to prosecute regardless of state law. Violent crime. Because marijuana is so valuable, there has been quite a bit of violent crime that is associated with it. I know that there are some unsolved double homicide up in Trinity County, which we believe is related to one group of people ripping off the marijuana load of another group of people. There was a trespasser on a marijuana field who was shot and killed down in Fresno recently. There have been a large number of home invasion robberies. When you have marijuana, a lot of people, particularly in this state, have guns to defend the marijuana. It's like defending your money. It's something that's valuable. People may want to come to get it, and so violence tends to follow where the marijuana is. Whether you're growing it under 215 or not growing it under 215, it's still worth a lot of money, and there's still that danger that's associated with it. And third, and probably most importantly, from my particular district's perspective, is marijuana grown on public lands. And I don't need to talk too much about that because that's not really within the scope of 215, but there is a heck of a lot of marijuana that's grown on public lands, on national forests and state forests throughout. In fact, about 75% of the marijuana that's eradicated every year in California comes off of public land. So that's a huge concern of ours. So there are a lot of different types of federal interests that intersect with marijuana that we're going to pursue regardless of Proposition 215. We have been successful in prosecuting cases in our office in which defendants raised what we call a 215 defense. That is, tried to claim that they were a legitimate dispensary, that they were operating under state law. One of them is a case involving U.S. versus Brian Epps. So very long battle that went on for years and years and years. He had been involved in marijuana trafficking prior to 215 passing, got back in the business under thinking it was legal under 215, but he's now doing a 10-year sentence. We prosecuted a case out of Modesto, a dispensary, a fellow who earned about $9 million in 2 years selling marijuana through a dispensary. He's also doing a 10-year sentence. Both of those cases have already been up to the Ninth Circuit and affirmed. We recently prosecuted a lawyer and his doctor wife, and they, I think, are surrendering to prison next week or the week after, who also claimed a medical necessity defense, and that case has also been up to the Ninth Circuit and has been affirmed. So whether or not people are claiming a 215 defense has not been an obstacle to us in pursuing cases that impact on federal interests. So all of this is not to say that we have not made any changes in our approach to marijuana cases. One of the things that we have ramped back on quite considerably are what we call 844 prosecutions. They are prosecutions of individuals for personal possession of personal amounts. So misdemeanor cases, small amounts. We have a large amount of federal land in this district, and so we routinely have park rangers and U.S. Forest Service people who come across individuals on federal land in possession of marijuana, and we are prosecuting many, many fewer of those than we were a few years ago. We still have a zero tolerance for military bases, and it's kind of amazing how many people get stopped on military bases with marijuana, and we do still prosecute those. So a warning to people who are going on military bases. But in general, those are our priority areas. We are not particularly interested in wading into this state law problem and becoming players in this debate in California, but there are a lot of federal interests at stake, and certainly when you get to larger grows, sort of commercial-type grows, that impacts a national market. That is something that is of concern to us, and that is something that we are likely to prosecute. And I'll just close by saying people, just to hopefully head off this question, which I know is coming, because I get it all the time. People say, okay, well, how much is too much? What if I just grow like 50 plants? Are you going to come after me if I grow 75 plants? And the question is a logical one, but not one that I'm going to answer, sorry. Because it's kind of like asking CHP, okay, I know it's 70, but if I go 80, will you cut me a break? If I go 90, is that too far? Basically, it's all, as I said at the beginning of my comments, it's all illegal under the Controlled Substances Act. And we retain the scope of jurisdiction to pursue. There are no safe harbors, regardless of what state law is. There are no safe harbors under the Controlled Substances Act. As a realistic matter, we have to prioritize and go after those areas that have an impact, that are important to federal interests, and where we think we can make a difference. We're not going to prosecute everybody, but we're not in the business of giving anybody sort of a clean bill of health in terms of prosecution from federal law. So, thank you.
Professor Caplan.
Well, so many references have been made to medical marijuana, and Mike Vitello read so well some of those lines that I was able to assist him with. That's a joke, that part. Not a jaw dropper. That I missed lunch, and I went back and abbreviated my remarks here. So I'm down from 8 to 3 pages. So if I don't make eye contact with you, engage you, think of the benefits in a shorter presentation, and you can actually. So, I begin with studying the basic framework. We have 14 states and the District of Columbia that have passed medical marijuana laws. They account for an enormous part of the population in the United States. About 27% is the estimate. So a lot of people are implicated by it. There have been suggestions throughout the morning that the motivating source was that this would be a way to back into legitimization or decriminalization of something of that sort. That wouldn't be my take on it, but I'll pay more attention to it now. I think the impulse was a humanitarian one. There were people in suffering from serious or terminal illnesses or chronic pain that didn't respond to treatment or medication that could benefit from it. And that to the extent that that's right, that was the motivating impulse, then I think that one can say that the medical marijuana laws have been successful. They've achieved that goal. So that is a significant achievement. On the other hand, the way these laws came about and the lack of regulation and so forth has produced a striking, dramatic series of unintended consequences that one would not have thought would flow from it. I'm going to give you the example of Colorado, although we have an expert from Colorado who can tell you to give you somewhat of an update on this. But it's prototypical of several states. It's hard to say how many. The part of the problem doing research here, it's really a black box. You want to know about Sacramento County? What's the age of the individuals that have certificates? What's their condition? How many dispensaries are there? How much are they earning? There's no data about that involved, so it's fugitive data. But from several states, we have quite good data, and we owe it more to the journalists than anybody else for making this available. But here's Colorado, which tracks California, maybe Montana, a couple other states quite accurately. In 2007. There was litigation in Colorado, and there's been successful litigation in California as well, both states, that challenged the 5-patient limitation for caregivers. So, under the statute, you could either grow your own or you could have, if it was too difficult or something of that sort, you could get somebody else to look after you. And as a result of this, in Colorado, the caregiver could take up to 50 patients. And as a result of this change in 2007, look what happened. Over the next 2 years, 1,000 dispensaries sprang up to serve more than 100,000 Coloradans who had discovered their need for medicinal marijuana and applied for a patient card. And I don't think, do I have the, I think I omitted the key statistic, wasn't it? It's after 2007, there were only 7,000 patients. I summarized a little bit, abbreviated a little bit too much. It went from 7,000 to 100,000 and is over 200,000 now. And Jon Stewart on television noted, I have a quote here, what had been considered the healthiest state in the country rapidly became one of the sickest. And then if you go to the blogs, you see representative comments like this. I have a very high tolerance, and a 2-dose lemon bar will put me on my behind. Or I love the buzz, which lasted 8 hours. Referring to the Rome Spice variety, a third found the strongest body high I've ever felt. It literally makes my whole body feel numb and tingly. I gave it a 12 out of 10 for pain. The health records from Colorado revealed only 2% of registered patients had cancer, 1% HIV/AIDS, and 94% claimed to suffer from severe pain. So that from looking at these 14 states as a whole, which is a practical matter, really meant about 5 of them that I could get decent data on, I extracted 5 propositions that I thought were unintended consequences. Now, this is not a normative presentation; it's a descriptive one. So I'm not evaluating them, but I think it's in a way it's an exercise in government regulation and characteristic problems that may well be conquered or adjusted in some way over time. Likely will happen. First, only a small percentage suffer from serious illnesses or end-of-life situations. Second, the great majority of patients are age-wise, you got it, young. 75%, looking at Montana, Colorado, probably California, are males under 40 complaining of chronic pain. So that's one would not have expected that. You would have thought there would be a lot of older people. They're not. And you know this. The problem with this presentation is it's accurate. I've got unexpected consequences, but everybody knows them. So nobody's surprised, which leads me to another generalization before I finish here. Third, and I thought that this was a little more surprising to me, is that one byproduct of the legislation is that we've created a whole new medical specialty. You know, there's oncologists, there's internists, and now there's marijuana specialists who, which is, of course, a bogus category. They call them rogue physicians is probably too harsh in the sense that they may have good intentions, but it's not practicing medicine. The AMA has, I think, covered itself pretty well in a responsible way by indicating what should occur in these interviews, but which doesn't occur. But they haven't taken the next step, or nobody has taken the next step in doing something with these doctors. And until that's taken, I don't think you can conquer any traffic that might be thought to be excessive. Let's see. In Colorado, more than 70% of doctors' recommendations were written by fewer than 15 patients, and I'm informed that's still pretty much, excuse me? 15 doctors. What did I say? 15 physicians, yeah, right. So who are these individuals? The point is here that I think when the act was passed, that we thought you'd go to your attending physician, and he would be familiar with your condition, and he would say, actually, my wife has somebody that she knows that he had an operation and he had digestive problems, and his doctor did prescribe for him. It didn't actually help, but the situation is that you go to a doctor that's never seen you, and you have an interview which is abbreviated, and of course the doctor doesn't know what he's prescribing in that sense. He doesn't know what the content, what's a TCH, what that content is, how it is, and et cetera. So that I thought was was been particularly unexpected. The fourth one I think has already been referenced, and that is that the birth of legitimizing assistance for patients has provided a cover for individuals that are in the recreational trade, that is, in the illegal trade. And that this has, for a host of reasons, eroded the capacity of law enforcement to be effective. So despite the best wishes, it's very difficult to all marijuana looks like. It's fungible. You can identify it. I think Colorado's taken a step in that direction, but it's not. So you have individuals that are moving into the black market. You have even growers. You probably know some in this that are growing and then selling. You get drug tourists in these states, so it's a mess. This was given my background was particularly on my mind. I won't say particularly my concern, but something that I saw that wasn't anticipated. I don't think one meant to undermine the effectiveness of law enforcement, but just put up for decent reasons, well-meaning reasons, something that would be helpful. And I don't mean to say that these people aren't that they're frauds. They may be suffering from pain. I mean, Mike says we all suffer from stress, but that's unpleasant. It's chronic, and if you can get a medication for it, and if aspirin would do it, but if you can get something for you which doesn't have untoward effects, it's not reprehensible to seek relief from pain and get pleasure at the same time. So one doesn't have to reach from evaluation from a value position for my presentation. I think by habit there's a pro law enforcement bias that creeps in. So I have to apologize to my students. I could say though that for my days here, as they mentioned that I was dean here for a while, I can tell you that there's a lot of people here using marijuana, and. And it's not because we're wiretapping or anything of that sort. It's because you leave your rooms a mess when you leave them. So when they clean up over the summer, they're pouring out the ashtrays. Who's made the reference to weed and whatever? And I pointed out that I'm trying to speak at the appropriate level to such a sophisticated audience here. So the fifth one is a little harder to grab a hold of, but it's the marketing one. So we were all familiar with this, and it's kind of astonishing, I think. I've got a magazine, I left it in my room, where we see a dispensaries taking out a page advertisement in a magazine called Kush. It's a multicolored magazine. It's quite attractive, $1,000 a page. And then we see the billboards and a variety of one. And then we see price competition in Colorado, right, coming up. Price competition. We actually see that here, but it's more subtle. It's in the form of discounts. So if you think of it as a medical ailment, then let's take something like cancer, and there's a new drug that comes on the market that will be soon. You wouldn't think that would double or triple the number of cancer patients. I think we all understand that in practice, through ingenuity and lack of investment buying, lack of forethought, a whole host of reasons, the regime hasn't turned out to be, it's turned out to be something quite different, although, as I indicated in the beginning, it has achieved I think the essential purpose of reaching that core group that they had in mind from the outset, although it would be a much smaller group. I have this down. I don't know if I want to pass this up. The marketing of medical marijuana seems geared to those who use marijuana for both pleasure and I added and pain relief, and then my rationale for that conclusion was the names of such products as White Widow, Grape Ape, Sugar Mama, White Rhino, Kong, Blue Dream, Grape Wreck, Super Skunk One, would seem to have no special appeal to someone experiencing nausea following chemotherapy. Okay? So my written version is a little more humorous, but I'm trying to speed it up, something. So, but that's why they suggest that the dispensary may have had the recreational user in mind. Now, from this, I step back and I draw two working hypotheses conclusion. One is, it sort of dawned on me along the way, and I mentioned to a couple of students, and they just nodded, so I thought, can't be that good, but it seems to me that the medically approved population, which would be a small part of the total group of users, but that population, which is significant in size, closely resembles or mimics the illegal market. So you don't, I got to quote, you can quote that. I'll repeat it. I'll get my grammar right this time. And one would have, and the reason that's significant, one would have thought just the opposite, that the medical market would have had a lot of old people and not a lot of young people. It would have had et cetera like that. But the more I thought about it, I said, these are the same two groups. Then my second conclusion, and my last, is that everything I said is very well understood. I don't think that there's people would say, I'm not going to have a whole bunch of people say, where's your data? I don't agree with you. That the anecdotal evidence is so powerful, even if I don't aggregate data. So I think, and here's where I began to mark alongside Mike, I think that the most significant byproduct of it is that it's created a public tolerance for this. And for teenagers, I have a teenage son, so this is a special concern to me. But for teenagers, it's sort of considered like smoking behind the barn was 50 years ago, like getting into the liquor cabinet was 20 years ago, and now. And with a lot of misinformation attending that, and an inability of parents to act decisively. I'm doing all right so far, but 3 of my sons' kids have dropped out of school or been trained out of school. And I asked the doctor about that, and I had a question. I said, might this be a pre-existing condition that was ameliorated by it? And he said, well, that's certainly a possibility. So one doesn't know what to make of it, or it's an atypical symptom, but it's sobering nonetheless. So I think, putting all that aside, what's my conclusion is that that medical marijuana experience has contributed and will continue to enhance the existing climate of tolerance for marijuana as a recreational drug. And I can't think of anybody that I've met that they're not interested in any of this. They want to know what my view is. I always say, well, my view, what's your views is, I have no special talent for giving a final conclusion on it. But what they want to discuss with me, they want me to say, well, I think there's not a problem here, So I think this is hardly a statistically significant sample, but I tend to think that the general population from the 1,000 or so pages I read here and there. Thank you very much for your patience.
Hi, I'm Sam Kamin. I come from the University of Denver, and I'd like to thank Mike and the Law Review folks for inviting me out here. I'm always thrilled to talk to people about medical marijuana, and particularly about Colorado's experience with it. As I was starting to say, I don't use PowerPoint a lot in my teaching, so the slides I put together for this presentation violate, I believe, every rule of how to use PowerPoints in teaching, except I think maybe for the picture. So what I'd like to do today is tell you a little bit about the work that I've done talking to people about medical marijuana in Colorado, and then what it tells us about the larger structures of federalism in our country, and what we can think about going forward. Okay, so let's see. My slides move slowly. What I want to do is talk about how this piece, what I'm talking about today, my larger project. I'm doing sort of oral histories with people that work in the medical marijuana industry in Colorado. I'm interviewing lawyers who are active in the movement, people who work with dispensaries. I've interviewed a bunch of law enforcement folks, political activists, which overlaps quite heavily with the lawyer group that is advocates for people in the industry, for patients, for doctors, and particularly with dispensary owners, people who are actively working in the industry. And what I can say, I've learned a lot about administrative law, that we have now a regulatory state in Colorado that regulates the marijuana industry in a way I think that's unique at least in the Western world. It's also been a story for me about socio-legal change. How do we go from a society that criminalizes marijuana, particularly, marijuana can be a 25-year felony under the federal system. If you're caught with a large amount of it, you can go to jail for a very long time. How do we go from that sort of a society to one that treats marijuana very differently? Criminal justice policy. We have had the war on crime now for at least since the 1970s. And how's that going for us so far? And then the last piece that really is my focus at the moment is the question of legal ethics. That is, in an industry where every sale that occurs in every one of the dispensaries in my state and every one of the co-ops in this state is a federal crime. That raises some real issues about the status of the lawyers that work in that industry. Right? What is it lawful for a lawyer to advise a marijuana client? Is it lawful for them to set up a marijuana client? Is it lawful for them to facilitate a wholesale of marijuana from a grower to a dispenser? So it's raised a lot of those issues for me. This is the face of medical marijuana in Colorado today. This is a woman who was quite cleverly dubbed by our local media the $5 joints lady. I don't know where they came up with that. But so this is a woman that was paid by a dispensary in Colorado to walk up and down. This is Federal Boulevard, one of our busier streets. And she is enticing medical patients to purchase their medicines at this particular pharmacy. Now, this looks slightly different than the way other pharmacies do their business. And the people that I speak to in the medical marijuana community in Colorado truly hate the $5 joints lady. Not her personally, but they hate that this is the face of the industry, right? That for people who are legitimate practitioners of medical marijuana, and I believe there are many people that sincerely believe in marijuana's medicinal benefits, this is not what they want on the front page of our local papers. And yet this is, in many ways, what people think about when they think about medical marijuana now, and I think it goes to what a lot of what Jerry was talking about, which is, we may have set out on a particular path, but this is where we have arrived, and that's troubling to a lot of people in the industry. So let me just give you a very quick history of medical marijuana in Colorado. You guys passed, California passed Prop 215, I think it was in 1995. We were a little bit behind you. We passed Amendment 20 5 years later in 2000. And then almost exactly nothing happened. As Jerry pointed out, we had very few registered users really for the first 8 years after our bill passed. Our bill looks a lot like yours. It creates a exemption from state criminal prosecution for particular people who are using medical marijuana or to those who are providing them with medical marijuana. Almost exactly nothing happens. And then, in talking to people, I said, so what happened in late 2008? What changed? And almost everyone said Barack Obama was elected president of the United States. That almost everyone saw this as a real change or that they hoped this would facilitate real change in federal drug policy. Even before the Ogden Memo that Mr. Wagner spoke about, there was this idea, maybe it was the pictures of Mr. Obama in his college days smoking what looks a lot like a joint that were floating around the internet, and that were, but people really thought this is going to change the way things are done. So, after 8 years of virtually nothing happening, suddenly we have a lot of dispensaries opening up. Our dispensaries are different than the co-ops out here. They are explicitly for profit. They are people selling marijuana to patients and doing so for a profit. How many of them opened up in the months after Obama was elected? Well, we don't know exactly because literally no one was keeping track. That is, there was no agency, there was no any part of local or state law enforcement. Nobody was keeping tabs. I talked to someone at our Department of Revenue, and he said, the governor came to me when all these stores were opening up and said, are you guys collecting tax from them? I said, well, no. And he said, well, start doing it. I said, okay, but and so they went to the back pages of our local news weekly and looked at the ads. And that's how they found out who was selling marijuana. It wasn't a lot of deep criminal investigative work. They just looked at the ads that were there in the newspaper, and this is what they found. So we don't know exactly how many dispensaries opened, but we do know how many users, that is, how many registered patients we had. And I have a chart that shows that. So the yellow line in this, I hope you can see the yellow line from back there. That's total number of registered users, and the red line is new users each month. And what that really shows is that until sometime in 2008, nothing was happening. Right? People weren't applying to be medical patients that could use marijuana. And then, right, either HIV or cancer or Other serious illnesses really must have spiked sometime in 2008 because suddenly a lot more people decided that they needed marijuana to help them. That was a joke. I often say to my students, I'll just raise a hand when I'm telling a joke. We can work together. So, right, what we see here is, we have a doctor with us. This looks like the growth of a unregulated organism, right? And it was an unregulated organism. There were no state, local, or federal regulations on our industry at all. People opened up dispensaries. People started selling this stuff for profit. Nobody knew whether that was okay or not. Dispensaries aren't explicitly mentioned in our state law. It was very unclear whether they would be permitted to stay open. And this was resolved by our legislature. In the spring of 2002, different bills were introduced in our legislature. One that was backed by the burgeoning marijuana industry would have essentially kept the status quo in place, and then there was a law enforcement bill that would have closed the dispensaries and gone back to what Jerry mentioned, the 5 patients per caregiver model, which would essentially have put the industry out of business. There were public hearings held, there was lobbying done on this, and the industry won. And I've interviewed a bunch of law enforcement folks, and I said, really, we had lobbying in the state, and you guys were lobbying against drug dealers, and the drug dealers beat you? You guys need new lobbyists. And I sort of asked them, how did that happen? That people that were selling marijuana for profit won in the legislature against law enforcement officials that were saying this will increase use by teens, this will increase crime, this will increase violent crime, organized crime. And what they said was, well, there was a recession going on. Right? And the folks in the legislature saw a new source of revenue. And by the way, I was mentioning this to someone at lunch. Nothing made the people in the industry happier than being taxed. Because what they said is once they get hooked on the tax money, they can't make us ever go away. Right? So we'll pay them 10%, whatever they want off the top, because once they put that money into the budget, and once they're used to getting money from us, we will be here forever. Right? And at least so far, they seem to be right. So we have this unusual circumstance in Colorado now, where if you pay your taxes, if you register with the state, if you comply with the requirements, and they're in some cases fairly onerous. One thing is that you can't have a felony record if you run a dispensary. Who do you think opened up dispensaries during the Wild West stage? Many of these people will say, we were marijuana dealers. Right? We knew where to get marijuana and how to sell it to people. And now they're saying you can't sell marijuana to people if you've ever been convicted of selling marijuana to people. Who's going to do this stuff for you guys if it's not us? So there have been some strange situations that have occurred in Colorado. But if you comply with all that, if you do the things the state asks of you, you can get a piece of paper from the state that says this person is authorized to sell marijuana to other people under the laws of our state. And I am pretty sure we are the only jurisdiction, I think anywhere in at least the Western world, that has said that here is a piece of paper that lets you sell marijuana for profit. Now, Mr. Wagner and whoever's in his position in the District of Colorado might have something to say about that, but within the state itself, the state is saying, we have marijuana laws in the books, we can still arrest people for marijuana, but not you. You can sell marijuana to certain people under certain conditions, and as I say, that is fairly unique. So the rest of my talk sort of has to do with how does Colorado and how does our experience with medical marijuana fit into the national picture, and what can it tell us about where things are headed? The big point for me is that we now really have 3 levels of marijuana regulation in the U.S. It is regulated by state, federal, and local law. We've heard about the federal law, that is the CSA, the Controlled Substances Act, prohibits the sale and manufacture of marijuana, period. There is no, as we were told, there is no medical use exception. There are quite clear federal precedents that say you can't cite a medical purpose when you're charged under the federal system with selling or manufacturing marijuana. In fact, one of the cases says explicitly it can't be mentioned in front of the jury, right? That it is not relevant in a federal prosecution that you were in compliance with state law. Therefore, it is not evidence that should appear before that jury. We also have now state laws, 14 states plus the District of Columbia. It's something that's now approaching a third of jurisdictions, and I think something close to half the population of the country. It helps that California is on board. Maybe it's not quite that high. I think it's probably also about a third of the population live in places where the states have permitted marijuana for some medical purposes. Okay, and then even within those states that authorize it, it can be regulated at the local level. So one of the things that happened when Colorado authorized medical marijuana is it said that counties were free to zone it as they saw fit, including zoning it out of business. That is, a municipality or a county could decide this is not a business we care to have within our state, and therefore we will not authorize any of these, and we'll close the ones that currently exist. Right? So you have what I think is really a unique set of circumstances. It's a federal crime, a very serious federal crime, a federal crime that can get you put in jail for 25 years or longer. It is, in California, and Colorado, and New Mexico, and New Jersey, a state right. It's not quite, it doesn't quite rise to the level of a constitutional right, but it is at least an affirmative defense to a charge of possession. And then at the local level, you have jurisdictions like Oakland that have encouraged this and have said, this is something we want to be known for. This is a tax source for us. We want to attract both customers and practitioners to see Oakland as the center of this new industry. And you have jurisdictions, at least in Colorado, that can say, we don't care for this industry. We're going to keep it away. So we have these three levels of regulation that really are functioning as differently as three levels of government can function. It's a serious felony. No, it's a constitutional right. We'd love to have you here. We're going to kick you out. Right? That's a strange set of regulations. Right? And imagine yourself in the position of someone trying to comply with this set of regulations. Right? It is virtually impossible. In fact, in the state-federal context, it is impossible to comply with both pieces. That is, you can't both sell marijuana in compliance with state law and in compliance with federal law because the feds believe every sale is a felony. Okay? I have a bunch of stuff here on the current state of law that I'm going to skip. I do want to say a word or two about legal ethics. I sort of mentioned this at the outset. All these slides are in the handout if you want to see what that's about. But I do want to say a few words about the legal ethics piece because I think it's a complicated one and one that's really going to come up in a bunch of different jurisdictions. So the model rule of professional conduct says a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal. Well, imagine you're the lawyer for a medical marijuana dispensary. Isn't everything you do assisting a client in conduct that you know to be criminal? Right? The United States Attorney for this district has just announced that what virtually everyone in the industry knows, which is this remains a serious federal crime. And yet you're the lawyer for this ongoing criminal enterprise. You do the things that help them run. You incorporated them. You wrote their leases. You wrote their employment agreements. You're doing their compliance work. Isn't everything that you do for them a facilitation? Aren't you assisting them in conduct you know to be criminal? And doesn't that make you complicit, either criminally or at least ethically, in the ongoing criminal violations of that enterprise? Now, there are certainly things that lawyers can't do, and I've talked to a lot of folks in the industry in Colorado, many of whom are my former students, and I've asked them some of these questions, and they felt, I think, like they're back in the classroom. But some of them have said, I got an email from a client, and the client runs a grow operation, and said, boy, we had a great month in the grow operation. We have 50 extra pounds this month. And you guys, I know that a bunch of your clients, he said to the lawyer, are dispensaries. Could you shoot an email around to your dispensary and see if anyone could use 50 extra pounds this month? Now you're laughing. right? Because you know that if the lawyer sends that email around, he is in at least ethical trauma, but he might have joined a conspiracy to violate. I won't ask, I'm not naming names, but you'll just sign. I have something I'd like you to. Yeah, good. No, right, but and let me say the lawyer did not send this email around. Just get that on the record. It's true, he did not send this email around. But it gave him pause. He said, well, I normally can help my clients, right? If I were, if this lawyer also has some bars and restaurants that are clients. He owns a distiller, a local distiller as a client. So, well, if someone had a lot of extra hops, I could certainly tell the breweries, hey, I've got, I know you guys buy a lot of hops. Someone has them you could get for cheap. So that wouldn't give me any pause, but this one sure does. The reason, of course, is, keep pointing at Mr. Wagner as if this is his fault. The reason, of course, is that the federal system continues to see this as a serious crime. So, this is an issue I'm actually spending a lot of time thinking about now. It's a really unresolved one at the moment, and I think the reason it's so difficult to resolve is that nothing else really looks like medical marijuana. I'm going to skip a little bit ahead so that we have some time for questions here. So I'd say this medical marijuana looks like but really is different than these other areas. There have been other areas where we see state, local, and federal systems at odds with one another, right? You can think of prostitution or gambling as these things that there's a prohibition on gambling over wires. Gambling is legal in Nevada, and there are parts of Nevada that have sports books and some parts that don't. So it is regulated at the three levels of government, but not quite in the same way. Other things, healthcare, right? The Attorney General in my state joined the lawsuit that a number of attorneys general filed against Obamacare. It's another one where it's something that's traditionally seen as regulated at the state level. A number of local jurisdictions will have their own rules about it, and now we're going to have federal legislation on top, right? You could talk about the civil rights laws, you could talk about the gay marriage laws, the Defense of Marriage Act, but none of these really have the same structure where they are treated so differently by the three levels of government. So this makes me think, okay, where are things headed? The first sentence, I think we can all agree, where things are now is untenable. Things will not look in 10 years, 20 years, 50 years the way they look today, right? We have, as Gerald was pointing out, there's something of a wink and a nod going on right now, right? It can't be that the sickest people, the people most in need of marijuana as medicine, happen to live in Boulder right across from the University of Colorado. Yet that's where the dispensaries are. Right? They are on college campuses. They are on busy streets. Right? We know what the patient profile looks like, and it looks a lot like they're recreational drug users. So we have, I think, at the moment, as with prohibition, a system that is that criminalizes something that's widespread and largely accepted. A book I came across in doing this is a book called The Cannabis Closet, which is sort of came out of the Andrew Sullivan blog on the Atlantic website. And it really is sort of a crowdsourced book, but it was contributions by his readers talking about their experiences using marijuana, either medically or recreationally. And his point was, and the reason they made a book out of it, these are people that look a lot like us, right? They're doctors, they're lawyers, they're parents, and they wanted to be able to share, look, there's lots of us out here, and we're criminals right now. In interviewing both practitioners in this industry, lawyers in this industry, one of the things that became really clear is that lots of people are using marijuana. One of the dispensary owners that I interviewed said, if you don't have any money, you can get across this country with a bag of marijuana. Right? You can buy gas with a bag of marijuana. You can get your car serviced. You can find a place to sleep. You can get food. The people out there on the roads, if you have a bag of marijuana, you can get whatever you want because it's that widespread. That many people are interested in having it. Another sort of disconnect between the criminal law and reality, one that I was talking to a couple folks about earlier, is the idea of file sharing. Right? Now, this one may seem like a bit of a stretch, but give me a minute. The the statutory damages for violations of the Copyright Act are $150,000 per use. Right? Anytime you willfully, it's statutory damages, they don't have to be awarded, but that's sort of a marker for how much damages can be in these cases. $150,000 per infringing use. I looked up on the web, how widely do we think that uses, copyrighted materials are downloaded illegally on the internet? One estimate was, say, 6 or 7 million files per month. I did the quick math there, and it's about $1 trillion a month. Right? If you multiply the damages per case by the number of cases, what you get is $1 trillion in damages. Well, that could close the budget gap pretty quickly, right? 3 or 4 months and we're done. The thing that's odd about that is we know that there's a disconnect. When the punishment per use is $150,000 and 6 million people or 6 million downloads are occurring every month, we see that the law is not being particularly effective at regulating. Why? Because there's a disconnect between what we say is criminal and what happens on the ground. And when that happens, something has to give. And you know, the other problem, as I say, and I'll sort of close with this, the system currently requires lying. Right? It requires someone to go before a doctor and say, boy, yeah, my spine, it's my back, it's this tennis elbow. It requires people that want to use marijuana to tell a lie to get it. Right? And there are other examples of the law requiring lies. Before there was no-fault divorce, for example, you had to show cause for divorce. The cause that was generally shown was infidelity. Right? How did you show infidelity? Well, there were lawyers who would say, okay, if you go to this hotel room at this particular time, there'll be a camera person there, I'll take a picture of you with this person, and then we'll say, oh, look, we caught the person cheating. Right? And there was this whole sham and fraud that had to be gone through to demonstrate that these people were entitled to get a divorce. The reason that fell apart is the whole system was built on lying. Our current medical marijuana system, there are people who sincerely want and need and use marijuana whom it helps. There are lots and lots and lots of people in Colorado and elsewhere who are lying to get the drug that they want to take. The system needs to come to some solution that no longer requires this lying. How that will happen, whether it will happen through the initiative process, as Mike was talking about earlier, whether it will happen through the rescheduling of marijuana as something other than a Schedule I narcotic, we don't know. But one of the things, I also teach a death penalty class, and one of the things I say is, I don't know how the death penalty gets abolished, but I know in 50 years we won't have it the way we have it today. I feel the same way about marijuana. It can't continue to be regulated the way it is today. So, thank you very much.
A couple of things I want to say in closing. One of which was we originally were scheduled for S4 and S5, and we were expecting about 60 people. And throughout the day, we were about twice as many. I think that the topic obviously is an interesting one. I've learned a great deal today. I didn't expect people from the industry to be here. A quite fascinating point of view. The one thing that I hope that that Katie and my perception that we didn't want to have the same old debate with the breathless advocates for and against. I hope we proved that that's correct. I think that today's speakers were really quite extraordinary. I learned so much and really was quite fascinated in all of your discussions. So thank you to the speakers and thank you for the audience for coming.